Mr. Chairman and members of the committee, thank you for the opportunity to speak about my experiences as the geographer of the voting section of the Civil Rights Division from 2000 to 2006. My service in the section was the highlight of my professional career. For a white Southerner born a year after the passage of the Voting Rights Act, and having devoted my career to studying both the South's sad racial history and its remarkable progress, enforcing a federal law born on the Edmund Pettus Bridge in Selma, Alabama was a high honor indeed. I'm also somewhat uncomfortable testifying. I had a very friendly relationship with John Tanner for most of the time that I worked with and for him, and speaking publicly about internal DOJ deliberations is not something I do lightly. Nonetheless, I hope that my experience at the ground level of voting section enforcement may be of some value to you in your oversight duties. Mr. Tanner's public comments earlier this month in Georgia and California could be overlooked if they were merely off-the-cuff remarks. Unfortunately for minority voters and unfortunately for the Department of Justice, the comments are actually a fair example of Tanner's approach to facts, the truth, and the law. Broad generalizations, deliberate misuse of statistics, and casual supposition, in my experience, were preferred over the analytical rigor, impartiality, and scrupulous attention to detail that had marked the work of the section prior to Tanner taking control in 2005. This decline and the myriad other problems that have developed in the section over the past several years are a direct result of the actions of political appointees such as Hans von Spakovsky and Bradley Schlossman. It has left behind a demoralized section, a growing list of lost court cases, and a severely diminished public trust in federal voting rights enforcement. While my written testimony discusses problems with other matters, including enforcement of Section 203 and the Ohio investigation in 2004, in the interest of time, I will focus here on the Georgia ID investigation. While it's not my intent to debate the merits of voter ID laws, I'd like to point out that even by the standards of subsequent voter ID laws, the Georgia law in 2005 was a nasty piece of legislation. No state endeavoring to pass a photo ID law now is considering the kind of draconian restrictions the DOJ endorsed in Georgia in August 2005. The restrictions that President Carter and Secretary Baker explicitly labeled as discriminatory when I worked for the Carter-Baker Commission at American University. Personally, I think that the issue is overblown on both sides, but clearly history, as well as the federal and state courts, will record that the 2005 Georgia voter ID law, pre-cleared by the Department of Justice, was a discriminatory one. All of us assigned to the investigation realized the department was almost certain to pre-clear it. Given the off-stated views of von Spakovsky and Tanner's eagerness to please him, none of us thought the department would lodge an objection. We simply wanted to do our jobs. That we were not allowed to do so demonstrates how the mission of the section has shifted from a search for evidence to support decision-making to a search for evidence to support decisions already made. I only have time to mention a few of the statistical errors, procedural violations, and misrepresentations that I discussed more fully in my written testimony. First, it is not true that racial data from the Georgia Department of Driver Services indicated that blacks were more likely than whites to have ID. It was not true in any of the data submissions from the state. The only way you reach that conclusion is if you include hundreds of thousands of non-citizens who are not black in your comparison. Mr. Tanner compares the number from the DDS to the VAP and not the citizen VAP, which is the more appropriate comparison if you're to use that data at all. And there are reasons in my written testimony why I don't think the data is trustworthy at all. It is not true that minority voters die before growing old. What this misses is the fact that black voters in Georgia who are elderly are more likely to be impoverished and therefore, I think, more likely not to have ID. This data that Lachlan referred to from Georgia in July of 2007, in fact, shows that African Americans make up 40% of those elderly voters who lack ID. Behind all great lies is a kernel of truth. It is not true that Tanner's pioneering actuarial theory was ever part of the 2005 analysis, but is instead a post hoc justification for an unjustifiable decision. It is not true that we were not reprimanded. We were each called into the office one by one and told that our performance during the Georgia ID was not up to the section. Now, it did not result in my case in any letter of reprimand, but we were certainly reprimanded, and Mr. Tanner needs to correct that statement. It is not true that a group of prominent law professors made racist statements about the impact of the ID law that Mr. Tanner dismissed as bizarre and offensive. And it's not true that we did not consider the poll tax. For Mr. Ellison's questions, the IDs were not free under the 2005 law. It was only under the subsequent 2006 law that the IDs were made free. To wrap up, John Tanner is both the cause and effect of the politicizing of the Civil Rights Division and should not be allowed to hide behind a career status which he has abjured by his actions. Until someone in the department, in this administration or the next, admits to the mistakes of the past several years and restores credible leadership, the voting section of the Civil Rights Division will remain a wounded institution. How long will the Department of Justice tolerate chronic mismanagement simply to save face? Thank you for your attention to this matter and for the opportunity to testify. I would, of course, be happy to answer any questions.